So I'm Phil Golding from the Law Commission of England and Wales, the Chief Executive. I'm going to do a double act today with Matthew Jolley, who's our Head of Legal at the Law Commission and a team manager for property, family and trust law. We're going to do 10 minutes each and then happy to take questions. I obviously haven't got the slides behind me, so just kind of bear with me on that, but there are some hard copies available. In terms of this audience, I'm not sure I need to spend a huge amount of time saying who we are, but I will just go through a couple of the high levels, I suppose. First of all, we are the only centre of expertise for law reform in England and Wales in terms of the government, sort of employed lawyers. We are completely independent, and our remit is terribly wide. It is to keep all the law of England and Wales under review. That's quite a big job. We are not a big organisation, so the reality is we can't possibly hope to keep all the law of England and Wales under review, and we'll talk a little bit more about how we prioritise what we take on. Also worth just pausing on is our sort of aims, as it were, and I think they're fourfold, as certainly stated on our website, at any rate. And that is to ensure that the law is fair, modern, simple and cost effective, which again is a pretty broad remit for an organisation of our size. And in terms of the size of the Commission, it's remained broadly constant since probably 2009-2010, which is when austerity started to bite. That is about 25 lawyers and about 20, a similar-ish number of research assistants. We have pared back massively on any administrative overheads, so there are now, including me, 6 non-legal staff at the Commission. It is mainly, our funds are used to fund lawyers and research assistants, in other words, what I've always referred to as our front line. Those people are, and I can say this as a non-lawyer, but we attract some of the best legal minds in the country. I think we attract people who want to come and work for the Law Commission. Quite a few of our people will take quite big salary reductions to come and work for us, and that is because I think they have a passion for law reform. So we're incredibly lucky, the people that we attract to come and work with us. I think also, and it underpins some of the themes of today, we have public trust, public confidence, I think. It's the sort of thing that is hard fought but easily lost. And again, it sort of underpins some of the themes today, which we'll talk about a little bit more. But we do, I think, have the trust of our stakeholders, and we do secure cooperation from across business, the public, and the legal community. And our job really is to try and build consensus so that the recommendations that we put forward are implementable. In terms of a few other bolt-ons that we have in-house parliamentary counsel, which we're incredibly fortunate to have. That number has reduced in recent years. We have had 3 in-house parliamentary counsel. The fixed number is really 2. One parliamentary counsel is working on our draft sentencing code exclusively, and we also employ an in-house economist, and we have comms expertise as part of our corporate services team. So we've kind of got a package of measures that we can put forward. So turning to independence, which is what I'll talk about before Matt moves on to implementation, and we'll try and draw it together. We are an independent statutory body. We were created by the 1965 Law Commissions Act, and that sort of independence is completely ingrained from a statutory point of view. In terms of the mechanics of it, we are now a non-departmental public body, which is a sort of status given to us in relation to our what's sometimes called arm's length from government. It's never quite clear how long the arm actually is, but sometimes that's best left undefined. And we, on the mechanics of it, I suppose, we are, Matt and I, Law Commission staff. We are not sort of separate from the MOJ. We are on their salary scales, our terms and conditions and the like. So in sort of logistical terms, we're quite close to the MOJ. We're in their building nowadays. We don't have our own headquarters anymore. But obviously that's just on the logistical terms. The actual independence of the organisation is clearly stated in statute. And it's fair to say that there's a bit of a tension there, really, because we're only part of MOJ, really, because of machinery of government. There's no real reason for us to be part of MOJ, because we actually undertake law reform on behalf of all of government. I think that's really important to stress, because I think, without wanting to sort of criticise MOJ, especially on camera, the slight tension, I think, is sometimes MOJ see us as their beast, and that they can kind of make use of us as though we're part of their resource, and we sometimes have to sort of say, no, actually we're there to provide for all of government. And I can't think of another NDPB that actually operates in that sort of way, where they've got a home department, but actually they're providing services across all of government. So there is a sort of inbuilt tension there as to whether or not the MOJ is the right home for us. That's a question that one could ask. Again, stressing that independence, although Matt and I are MOJ staff, our commissioners most certainly are not. We have 4 independent commissioners covering 4 legal disciplines, essentially, and they are public appointments. They are appointed under the guise of the Commissioner for Public Appointments through an independent process, albeit approved by MOJ ministers. And our chair is a Court of Appeal judge, most recently Sir Nick Green, who's been appointed a couple of months ago. And so the way that the Law Commission works through those commissioners is the product of the commission is those 5 independent commissioners, and so although Matt does all the work, it's those 5 who are doing the product that comes out, and it must be them that approves it. I think it's fair to say that historically, and Enrico alluded to this, the Commission was largely free to select which work to undertake, but since the 2010 protocol that came between the Commission and government, which states that the government must have a serious intention to legislate or to take forward law reform, it does create potentially an area of tension, again, with how we take on work. On the plus side, I think it's fair to say that it means that there is a real priority behind the work that we do, and so it reduces that risk that we spend a large amount of time coming up with proposals that then sit on a shelf because government says we'll take very much, but actually we're not interested. So you can see what the aims were behind that protocol. The downside is, and I think we are seeing this, and anybody who looks at our programme of law reform, which was published at the tail end of last year, our 13th programme, I think we possibly see elements of this, is that the capacity to take on what might be classed as lower priority work by government is constrained. That is undoubtedly the case, and we'll talk a little bit more about the sort of balance of work as it is at the Commission. All of that said, it is important to stress that the Commission has criteria for why they take on a particular project, and at no point, since my time at any rate, have I seen any pressure applied to commissioners to either undertake or not undertake a particular project that's reached a particular stage of planning. It's more about whether or not the logistics behind some of our decisions we have quite as much freedom as perhaps is sometimes suggested. Some headline figures. The Law Commission budget has been cut by 54% since 2010. It was, roughly speaking, about £4 million per year from the Ministry of Justice back in 2010. That is due to drop to 1.9 million next year as part of the spending review settlement. That is an extraordinary level of cuts for an organisation to absorb. The positive news, and why we haven't gone out of business and are still viable, I would say, is that in 2010 we brought in £200,000 worth of income. This year it is projected to be £1.8 million worth of income. Now, that income is not us going around touting to law firms or anybody who will cough up some cash. We can only bring in money from Whitehall, essentially, and so we will now perform or undertake projects, essentially, that a Whitehall department that isn't MOJ, usually, will say, here's some money for it. And we have a charging model in place for that, so it's all quite transparent. It's usually £150,000 for a one lawyer, one research assistant project, which then covers some overheads, communications, publication costs and the like, and we're completely transparent about that. There are memoranda of understanding signed off with departments to make sure that they know how we are spending their money, and we have to report back to them. And we're not allowed to cross-fund, essentially. So I can't take money from, I don't know, say the Home Office hate crime project and say, actually I'm a little bit short over here on a core funded project, I'll use some of their cash to help me deliver another project. They don't like that very much, I think it's fair to say. So although on the surface it looks as though we've delivered an equal budget, roughly £4 million a year, you can see the balance of how that budget is made up has changed dramatically in a fairly short period of time. The plus side of it is that we have been able to maintain our capacity and expertise. Our headcount, as I said before, is roughly the same as it was back in 2010 for that amount of taxpayers' money. I would argue, and I think it's borne out by our publication rates, is that I think we're a more efficient organisation. I think we are doing far more law reform for the money that we are given by the taxpayer. But you can see how that balance, that shifting balance, means that we are under far more pressure to go out around Whitehall and get money-making projects. There is no way around that. Now, I don't think we are undertaking any projects at the moment in the law column that we wouldn't want to be undertaking, just because somebody waved a check in our direction. But you can see that there is a potential future risk there, and I'm going to hand over to Matt at that point, because I think I've used my time up, to discuss that aspect, and then we'll take some questions. Thanks.
Thank you. So this is all slightly mixed up in whether we're talking about implementation or independence, but moving on the first slide of implementation, I think this shows there remain grounds on which the Law Commission is able to paint a positive story of where we are with implementation. There's the oft-quoted statistic, which I think Jonathan will recognise from his time at the Commission. We're still saying that 66% of Law Commission recommendations are implemented either in full or in part. Now, in part very rarely means that they've taken what we've said, changed yes to no, and said that that's implemented. It usually means substantial implementation, but it obviously varies, and that statistic does bear scrutiny in that respect. 66% against a backdrop of the fact that there are very good reasons why anybody, a law reform body, a government department, cannot expect everything it does to be implemented. Things can change. A law reform report can be superseded by a court decision, other change in the law. A government can change. Parliamentary pressures are always an issue for us. It is very difficult to get primary legislation in particular through Parliament at any time, especially at the moment, but at any time. And in fact, if you look at how much primary legislation in particular the Law Commission produces, as against the amount of law that goes through Parliament each year, we have quite a decent chunk of it over the years. There are lots of departments that will get a bill through a session, and that usually would want to be one of the ministerial priorities, and we are there saying, no, you should really be doing what the Law Commission has said. So that status is telling, and it is good. The final slide on that page puts it the other way around. How many law reports actually get turned down? Of 350 sets of law reform recommendations, less than 10% rejected, and only 3 reports rejected in the last 15 years. So, putting aside independence for a second, implementation is something that you could want to be improved, but it is not at a terrible level. There is, however, another category where we have reports which have not been rejected, but they've not been implemented. The protocol that Phil has described says that government will provide an interim response on any Law Commission report within 6 months, and a final response within a year. That, if you wanted forensically to go through things, has not always been adhered to. There are reports where the recommendations have been made several years ago where government has not given a final response, or has given a response that it says is a final response, but it isn't yes or no. It's a we will continue to monitor the situation type response. Whether that's in satisfaction or within the spirit of what the protocol suggested, leave others to judge. it's sometimes in the Law Commission's interest not to push a point. If we know that the politics of a situation or the fiscal situation in a particular area is such that it would be very difficult for government to say yes at a particular time to a set of recommendations, do we want to say your time is up, you've got to say yes or no, or is it actually better for the law reform process, that the chances of the law changing, for us to say, okay, put it on hold for now and come back at another time? Pragmatism comes into that as well. Another development that was brought in by the 2010 Law Commission Act was the annual implementation report by the Lord Chancellor, giving an update on the progress on implementation of Law Commission recommendations. And that has happened not exactly every year. You'll notice there's an 18-month jump at one point, and we had 2 reports in about 3 months of each other. But there is a process by which the Lord Chancellor has to lay a report in Parliament, a detailed report, for every Law Commission project where we've made recommendations and a final response hasn't been given, saying what is happening to that. And the idea is that which obviously puts pressure on the Lord Chancellor and the officials who have to prepare that, and gives the opportunity for parliamentarians to hold the government and the Lord Chancellor to account for what's happening or what's not happening. I think that's been a very useful thing. It does focus minds, but if you look at the content of some of the Lord Chancellor's reports, in some areas you will see, I have a particular project in mind which I will not say because it will get back to the officials involved, that it would say we hope to give a final response in 2009, post 2009, 2014. And then next year it says they hope to give a response in 2015, 2016. So, you know, there is a report being made, but what is the quality of that report? And generally, there has not been a huge amount of parliamentary scrutiny of that report. The occasional question has been asked, but it is not a particularly active process by which there is scrutiny as to whether the answers that are being given and the report that's being given is in fact satisfactory. The figures that we've got here are currently 22 projects awaiting a response. Criminal law reforms particularly being seen to be left in abeyance. To an extent, I think you probably add family law to that list, and some areas of property law. There will be a number of reasons for that, either because the report is not seen to be high enough priority to get to the top of government's list, or sometimes it's a little bit too hot for the political context at that time for it to be taken forward. So turning over to the next slide, does that mean that the government doesn't want what the Law Commission produces? Well, the evidence seems to be not. The 13th programme does demonstrate the ongoing relevance of the Commission. We've got projects on autonomous vehicles, smart contracts, residential leasehold, and a wide range of other areas, all of which are very high-profile issues for government and represent an immediate need to government to respond to either problems that are high-profile in the news, causing problems clearly on the ground, or which affect future developments on which it appears that there's a desire to build our future prosperity as a nation. So we're not sidelined into doing minor pieces of work, and there is no lack of demand. As it says here, the full order book demonstrates that the government sees the Commission as supporting its key policy objectives. There we have something where we're saying the Law Commission is doing a good job. It's doing a good job which supports government objectives. How does that go to independence? So then we have the question, independence and implementation, are they in harmony? And I'd argue that there's a very complex relationship here. The 2010 protocol and the reliance on income-producing projects that Phil described have made it more likely that our recommendations will be implemented. We are only doing, in those areas, we are doing work which a minister has said there is serious intention to implement law reform, or that in cash-strapped times, a department which won't have a lot of money to spend on anything is spending money on us to do something. That leads to, well, to start with, it means that we're only going to get asked about that in areas where there is more of a desire to do something. It also leads to accountability within the department, the sort of imperial leather effect. If something's expensive, it must be worth having. an area where, so there you can say that the giving up of independence has helped implementation. An area where the independence and implementation, I'd say, are more in harmony, it relates to the special procedure. And this is the parliamentary procedure for Law Commission acts, where a government will take forward a bill, but if it's based on what the Law Commission recommended, and the usual channels and parliamentary authorities are in agreement that the subject matter is sufficiently uncontroversial, then there's a special procedure which essentially means that a Law Commission set of recommendations can be implemented alongside main government business with a slightly different parliamentary procedure, but still full accountability. In essence, it gets law reform as an extra beyond everything else government wants to do. And that can be incredibly useful to take law reform forward. That is based on the fact that there is parliamentary trust in the Law Commission, hopefully doing a good job, but certainly doing an independent job. And as a result, Parliament is willing to accept a slightly different form of scrutiny. What's the wider impact of these interplays between independence and implementation? Well, Phil's mentioned there is a risk that we will only get to work in areas which are government priorities. That's a result of the protocol. A government department, if a minister doesn't think something is a priority, the minister will refuse to give the protocol support that there's a serious intention to take forward law reform. And it's money. If we can't afford to do a piece of work, however much we would like to do a piece of work, we cannot do it. So government has the purse strings, government can control how much we do and can make it more likely that we do a particular piece of work by offering money for us to do it. When we're in that situation, how do we ensure in receipt of funds from government that we are doing an independent job? Well, sometimes government does have an idea of the form of law reform that it is wanting to achieve. And in those circumstances, there will be situations where the picture of what government wants to achieve is too clear and too determinative, and there is not space for an independent project to be done, in which case we step back and say that's not useful areas for us to work in. In other areas, we're able to conduct what we consider to be useful law reform within parameters by ensuring complete transparency and having very clear terms of reference. As an example I could give, we're currently doing a project on enfranchisement, extending leases or allowing leaseholders to buy the freehold of their properties, where one of the central issues is the price that should be paid in order to extend a lease or buy a freehold. That is essentially not a legal question. That's a social policy, social policy or political question. What should be the balance between freeholders and leaseholders? And legal analysis cannot give you the answer to that. Government has a clear picture of what it wants to do and has asked us to design a system that would make it cheaper for leaseholders to enfranchise, and to give government options on how technically they might set the price. There we can say independently our task is to do that, but it is transparent what our task is, and that's made what would be a very complicated discussion with leaseholders much clearer, because we can say we are operating on creating a system that works better for everybody and fulfills that particular imprimatur to make the price lower. Does this mean that less high profile but still important areas of the laws get missed? It certainly risks that, and it certainly makes it much harder to work on those sort of areas. The example given in the slide is statute law appeals, which is the task of looking through the statute book for obsolete areas of law. We have a practitioner in the room. That is not something that the Commission is able to prioritise at the moment, because we do not have either the funds to do it, or actually much of a suggestion that government is currently interested in it, as can be seen by the speed at which the last set of statute law appeals recommendations have been taken forward. It isn't just a particular area like statute law appeals. Any area of law that is not newsworthy, where there isn't an obvious saving for government or direct benefit for government, can fall into the category of not being a priority. And that's always been an issue, but when we have to pass the protocol test and we have funding limitations, that becomes all the more difficult and pressing a problem. And areas that can be a real benefit to individuals fairness or just making life a little bit better, or indeed businesses, which one might be a bit surprised about. The technical law affecting businesses is not more of a priority, can get lost in the gaps. As Phil said, there's no question that the Commission's choice of work is being constrained in the sense that we're not being told what we must do. We're not finding it impossible to do the types of work which I've described as being difficult to do. Our 13th programme includes, for example, a project on disposal of the dead, which is a project I've been trying to get government to be interested in from way before the protocol, in fact, and in fact it has found its place. Likewise, the very specialist members of the audience will have been excited to see that we have a project on some land registration issues around chancel repair liability in the programme. I don't think it's fair to say that's going to be a government priority, so it would be simplistic to say we can't do that work. But that work's currently in the programme. In the programme of work, the list of projects that we would like to do, it doesn't mean that we're able to do them. At the moment, we're not working either on disposal of the dead or chancel repair liability. And so there are difficult choices about how we prioritise this category of work, which is very, if we can get it onto our books, how do we then actually afford to do it? Has the balance shifted too far between core funded work and income generated work? Yes. And we've given evidence to the Justice Committee that we feel that that is the case and it's having an impact on our independence. And the Justice Committee report comments essentially in agreement on that. There seems to be an emerging consensus actually across government that that's the case. As the slide says, there is no money, so it'll be interesting to see what the response to that is. So, in conclusion, there is a complex relationship between independence and implementation. Frankly, if we are working closely with government, we are more likely to be doing the type of things that government is interested in, and that's more likely to be taken forward and implemented. It's not straightforward. Government has also implemented reforms in areas such as classification of trust law on perpetuities and accumulations, largely using the special procedure for Law Commission recommendations. It's something that will, I believe, always be in tension. I think from the Law Commission's perspective, especially on the financial side, which I think has actually probably got more of an immediate impact on us now than the protocol, I think it is just important that we hold the line that the Law Commission is here to look at as much of the law as we can to benefit citizens, businesses and governments, and that we should be doing that independently, and that should be given the respect it deserves and taken forward. And that's where we stand. Thank you.